The appropriate good morning to everyone, and afternoon or evening, wherever you may be. It's really a pleasure to be here and to try and give you some pointers from our research and our thinking that is reflected, as you will see in our background note when you have the chance to read it, which is a background note on the role for competition authorities for the recovery. I'm going to make 3 points, and one is that the lessons to be learned there are lessons to be learned from previous crises, and maybe when in your advocacy efforts you might wish to draw on the evidence that we collect in the paper to make your point with governments. The second one is that this may require, this phase may require an increased focus on advocacy, given the level of government interventions that can distort competition in markets that we are seeing. And the last point relates to some of the enforcement challenges that Fred has already alluded to, some of them. So first, what have we learned? Is this time different? We've had recessions before, but what does this mean for the role of competition? As Bernanke said, seismologists learn more from one large earthquake from a dozen small tremors. And looking back at previous moments of big economic hardship, such as the Great Depression, the Japanese crisis of the 90s, the global financial crisis, we learned that lax cartel enforcement and merger control in times of crisis holds back recovery and does not improve resilience. And advocacy can become particularly important in these times. Changes done now can have lingering effects on competition for a very long time, perhaps even decades. Let me give you an example. After strong lobbying, the aviation sector in the 1930s saw the imposition of restrictive regulation for new players until deregulation decades later in the 1970s. This brings me to my second point regarding the increased role for advocacy. Structural change also means that governments may be ready to embrace reforms. Competition authorities, therefore, may wish to push for reforms, such as the example that we'll hear about from Mexico's COFECE today. Just as importantly is the role that competition authorities may have now and will continue to have in the design of all the government measures to address the crisis and recovery. Competition must be taken into account in a wider policy agenda for recovery. Very few of you have enforcement powers regarding state support, and the EU being an example of one who does. However, virtually all of you have advocacy powers, meaning the possibility of advising governments and providing opinions. And whenever governments decide to subsidize or otherwise aid a firm, this may lead to competition distortions that can have a long-term legacy. It may force those firms who are perhaps more efficient to downsize or even exit. So you may be called upon or decide to provide advice to help minimize those distortions. The alternative is to spend the following years trying to address the problems created with enforcement actions when you already have stretched resources. In the paper, we offer a number of economic principles that can provide pointers on how you can analyze a particular state measure. Of course, there's no suggestion here of being dogmatic. There may be very good reasons for state support. Further, competition should inform the design of industrial policy measures, helping ensure that through the reduction of regulatory barriers to entry, for example, competition may be embedded into the wider industrial policy agendas. The bottom line is that if governments decide to shape markets, competition agencies may help them ensure they do so by guaranteeing the principle of competition. The third point I want to make relates to enforcement. Prioritization becomes fundamental in order to support the economy, and competition authorities may have to redirect enforcement towards strategic markets and industries that may lie at the heart of the recovery process. This, of course, will depend on what your economy looks like. You may also have to prioritize those sectors that have huge spillover effects, or that have, or where cooperation agreements were made to ensure that the latter do not exceed the initial time and scope and do not end up degenerating into hardcore cartels. There will also be calls for crisis cartels. We saw that last time round. This should be met with extreme caution by competition authorities and really be considered only in very extreme circumstances where, in the absence of the agreement, the competitive structure of the market would deteriorate to at least the same extent as with the agreement. As regards abusive dominance, in times of crisis, many firms may exit. leading to increased market power for those who do remain in the market. Others may become financially weaker, and those firms with deep pockets can take advantage of the fragility of competitors. This may lead to a heightened risk of exclusionary behaviors, such as predatory pricing and other exclusionary strategies. Competition authorities need to be alert to exclusionary abuses and be prepared to move fast where appropriate, perhaps with interim measures to avoid irreparable harm. As regards merger control, we point to the need to continue to strictly apply it and to strictly apply the failing firm defense, even more so in circumstances where markets are expected to bounce back. We must bear in mind that mergers are forever. Firms often have the opportunity to restructure, downsize, and become competitive again, and they should be given the opportunity if it's appropriate. However, expedited reviews for failing firm defense cases might be envisaged, in particular where there seems to be a good case and the likely magnitude of the consumer harm is low. In conclusion, competition and competition authorities can play a role, or even a key role, in the recovery of our economies. So I'm looking forward to the debate. Thank you very much, Fred.